I hope to give you a brief overview of IP management today and make it as interesting as possible. OUI is the Tech Transfer Office for Oxford University, and we support Oxford academics translating their research and their knowledge into real-world impact. And we do that through various different services, through licensing activities, through spin-out activities, consulting activities, and investments. Other than that, we also help and support Oxford academics who are writing or about to apply for translational funding. And we give them advice on intellectual property management and their commercialization strategy. So there are a number of different NIHR programs where IP management matters. I won't go through each of them. I have provided the links here to the NIHR guidance for each. The link on the top is for the domestic programs funding guidance for all the applications. And the bottom link is specifically for the intellectual property and commercialization guidance. And obviously, I encourage you to go through those very carefully. But I did want to highlight a number of things that you should take into account when you're generating your application for these programs. The first is that the IP expectations vary by program and by funding agreement. So you need to know where the focus is on the particular program that you are applying for. Secondly, commercialization planning is becoming increasingly more important. And therefore you need to have a plan from where the research you're planning to do right through to patient benefit. The NIHR are putting a lot of emphasis on robust governance of industrial collaboration, and you need to ensure that you will have all the right agreements in place to govern any collaborations that you intend to carry out. And finally, this is like linking to Dean's presentation, the publication or the dissemination strategy and the IP protection strategies must be fully aligned. So why does intellectual property matter? Well, often innovation without protection often loses impact. So when you're at the beginning of your journey, when you're doing your research, you are thinking about how this is going to improve the patient's life. But what you really need to think about is how it's going to get from your research to the patient. And there is a pathway there through partnership and commercialization. And in order to enable that, you need to make sure that you have the right protections in place, that you've protected the research that you has taken place, and that you're able to enable the next steps in the process. So intellectual property enables translation from idea to patient impact. Because you've protected it, it protects the investments that NIHR have made in the research and development. Because if you have some protections in place over your research, it encourages further partnerships with industry. And if you need to do further funding applications, having your research protected supports that. And of course, if you want to, you can then also license those protections out. Or if you wish to bring this to market yourself, you can use those protections to set up a spin out, because you'll be able to attract funding when you've protection in place. So really, intellectual property is essential if you want to scale healthcare innovation. But what is it? A very simplistic description of it here. It is a creative product of the mind that has commercial value that can be bought, sold, or rented, like a house or a car. And there is a legal framework that exists throughout the world that protects those who create, sell, and buy this. And this is the intellectual property rights. Well, the first thing you need to be able to do if you're creating an IP strategy is actually be able to identify IP. So this table summarizes all the different forms of intellectual property rights that you could have. The first one are patents. This is the one that most people think about when they think about intellectual property, but it is very specific for what it can be used for. It is used for new inventions, and new inventions have specific requirements they have to meet. They have to be novel. There has to be no other. This is not has evidence of it being done before. It needs to be inventive, so it needs to have shown that there's some sort of inventive step or some sort of new thing that has now happened that had not happened before. It needs to be applicable, which means it needs to show that it has an industrial or a use application. And it needs to be enabling. And that means that somebody with reasonable knowledge in the area will be able to take your patent and be able to practice it. Now, you don't just get these automatically. You need to apply for it. And there's an extensive examination process afterwards. But if you do get a patent granted, you can have 20 years plus lifetime on that patent. But patenting is not for the faint-hearted. It is a very complicated process. You will need to get expert advice. If you're in a university, you absolutely need to speak to your tech transfer office. If you're not, you need to speak to a patent attorney. It can be extremely expensive. So patenting is not something that you should do every time, just when it makes sense. The next form of IP that is copyright. I think everybody might have seen a copyright symbol. You'll see a few of them in my presentation today. And it's a protection of original creative or artistic form. So it can cover web content, recordings, source code, object code, or questionnaires. It exists automatically. And it exists for the life of the person who has created the copyright plus 70 years, but that varies from jurisdiction to jurisdiction. The next one is database right. This covers an original collation of a database. That means you need to have put some sort of effort into creating that database. It protects against copying of the database, but not the data itself. It exists automatically and it survives for 15 years from the creation of the database. You will have probably also seen trademarks. They protect, they're unique words or symbols that identify a product or service. You can get these in two different ways, by either using them or registering them. And they last indefinitely as long as you're using them. If you don't use them, you can lose the trademarking rights. The next are design rights. These cover the external appearance of something. They also can exist automatically, or you can register to cover design rights. And these survive for a maximum of 25 years, but you need to renew them every 5 years. And lastly, trade secrets. These are extremely important. A lot of companies use trade secrets as their IP. It covers know-how or certain methods that other people don't know how to do in order to create a product, or source code. But trade secrets only exist as long as they're a secret. So keeping something a trade secret requires a lot of work. You need to ensure that you've got confidentiality in your employment agreements, that you have confidentiality with anybody who has any information around the trade secret. You need to ensure that you have firewalls in place so that no one can get the trade secret. Often you need to have operational controls so that maybe one person knows part of the secret and another person knows other parts of the secret. So not one person could share everything. I think one of the most famous uses of a trade secret is the Coca-Cola recipe. That is a trade secret. So now you should be able to identify the IP that is in your research. So the next step is to identify the most common mistakes that can be made so that you can create strategy to avoid them. So the key risks are disclosing or disseminating before you protect, having an unclear ownership across collaborators, having freedom to operate issues, and incorrectly using third-party IP. And I'm going to go through each of these in a little bit more detail. So of course, dissemination is extremely important. But if you disclose too early, your good idea will lose protection. Any good commercial strategy will involve a dissemination process, a dissemination strategy. So it's not about not publishing or not presenting or not collaborating. It's all about timing. It's about making sure you've protected before you've done any of those things. So for instance, if you're about to publish a paper, if you publish before you put the right protections in place, if you wanted to patent, you may lose the right to patent. And then your competitors can see and copy and file. That will make it more difficult for you to see the impact you want if you intend to go through the commercialization route. So plan your publication in parallel with protection. Also, you may want to present your work. Ideally, you would file whatever protections you would need before you even do your abstract. You file your abstract. Because you need to know that the abstract review process may not be fully confidential. Ideally, file your protection before you apply, but the next step would be to ensure that you've no confidential information in the abstract's submission. But get advice from those who either a TTO or a patent attorney has to understand whether there is a potential disclosure in the abstract. And finally, yes, absolutely do need to collaborate, but ensure that you have a confidentiality agreement in place before you have any serious conversations about the work. Make sure that confidentiality agreement is specific to the work that you want to discuss. So it's not very broad. Make sure that all the relevant stakeholders that need to discuss it are named or covered by that CDA. And also remember, if you've got a CDA in place, it doesn't mean you have to share information. It just means that you can with safety. So just share information for the purposes of the collaboration, and don't share anything else. An issue we see quite often is ambiguity around the ownership of IP in research. If you cannot easily identify who the owners of IP is, it's going to be very difficult to commercialize that technology. Employment contracts are often determine who owns an IP, so who people work for. It will be in their contract how their ideas, whether it's owned by the university or what their ownership is. But if you've got multiple institutions working together, such as the NHS or universities or industry, all of those may have rights to the research. And on top of that, funders may also have rights to ownership as part of the funding agreement. So if you don't have the right agreements in place, joint ownership can become very complex and may make it almost impossible to commercialize your technology, and or even to get the impact with the patient. So it's very important to ensure that if you plan to have collaborations, that the right agreements are in place that cover background IP, so IP that already exists, the IP that is, and IP that is about to be created, and who owns what. So next, there's many potential sources of freedom to operate issues. So freedom to operate means the ability to develop or sell a product without infringing on somebody else's IP. So what you need to be able to see is where could other people's IP come into play in your grant application. So you need to look at the past research, the research that you're going to base your application on. And this is what you're looking for is background IP. You need to then look through the research you're planning in this grant application. What IP, third-party IP will you need to use? What arising IP will there be, so that you can ensure that there's no freedom to operate issues. And because we are now having to look into the future at potential commercialization of your technology, you're going to have to look at what could have potentially affect commercialization. So these are kind of examples of what you could potentially see. So in past research, you need to look at the previous institutions and funders and commercial collaborators that were involved. And you need to look at what your reliance is on third-party IP, for instance, if you've used software. In your future research, you need to look at the what is required, what licenses are needed if you're going to use patient data or samples. If you need to use resources from the NHS or the university, what sort of permissions do you need for that? And if you're working with third parties or such as contractors, how will their contribution affect your freedom to operate? And for commercialization, you should look at what patents exist that may cover your invention. So I will go through each of these in a little bit more detail now. So you want to avoid the hidden legal and commercial risks around using third-party IP. When we talk about third-party IP, we're talking about images and figures, open source code, clinical questionnaires, proprietary data sets, and AI models. So just because you are using third-party material doesn't automatically mean you have the permission to use it, even for research, especially for commercialization. So you need to check licenses before using software, data sets, images, questionnaires, or code. Open source software may also require complex obligations. And this is particularly important where you have AI, digital health, or medtech projects, because they often combine multiple external IP sources. So you might need to put data material transfer agreements in place, or data sharing agreements. But once you have collated all your permissions and licensing terms, keep clear records of all of these for the future. There are some more complications when you're looking at samples and data materials that you may want to use in your research. In particular, if you've got like patient data or blood samples or medical scans, like patient-derived data, you need to ensure that there are the correct consents from those patients to allow for you to commercialize that technology, or even so often they would have given consent to research, but they may not have given you consent to use that technology to create commercialized product. You will also have to make sure that any data you're using is functionally anonymized. And you may have gotten access to animal models, antibodies, and cell lines. Again, you may only have those for research use only. So you need to make sure that you can use them for non-commercial purposes. So how can you tell whether a patent exists that may infringe your research. I mean, this is quite difficult very early on, especially if you don't have a clear idea of what your invention is going to be yet. But what you do need to do is do some patent landscaping. And that is essentially just working out what patents exist that you might infringe. So to do patent landscaping, you need to work out what are the key aspects of your patent that makes it that of your invention that you may form claims in a patent later. You can then use some online software like Google Patents or Spasnet, or if you have access to a TTO, or you may be able to get access to some paid versions of patent landscaping software. And you can work out what patents exist that your patent might infringe on. Often you will get a lot of patents. So you may need to work out ways of filtering that down into patents that are most likely to be the ones that are important for you. So often doing some competitor analysis to work out what the competitive space is in order to work out what sort of patents they have might help you work out how to work in and around that space. And then also you may need to work out if there's other licenses to third-party patents that you might need to be able to get. So I'm just going to go through an example of what this might look like. It's the very basic example. Say, for instance, you have developed a biosensor, and this biosensor enables non-invasive accurate measurements of blood glucose through sweat. And it's suitable for mobile devices, so it can be incorporated into watches, wristbands, headbands, skin patches, or jewelry. And you've now filed a patent. This is a little bit out of date, but you have a patent, and now you want to work out, well, what is my commercialization strategy for this? What is my patent landscape? So the patent landscaping for this looks like this. So this is the annual application trend in non-invasive blood glucose sensor sector from 2005 to 2024. The blue bars are the number of patent applications that have been submitted. The green bars are the number of patents that were issued. You can see that this is a very, very crowded space. Quite a lot of patents have been applied for it, particularly after 2017. And so this is a lot of patents for you to have to look through to see whether you are infringing them. So as I said, one of the things you could do is to look at the competitors in the space and then work out what patents they have and what those main claims of those patents are. So you can see here out of 1, 2, 3, 4, 5 main competitors and many other minor competitors, they have patents across many different aspects of a biosensor. And so partly what this will tell you is that, well, first of all, it's a crowded space. Second of all, there are patents that exist in and around the same sort of claims that your patent is making. But the next thing it can tell you is that the competitors have patents across all of these different aspects. So what you might need to do is either work out how you can get access to these other patents, but through licensing, or maybe the best route to market might be you licensing your patent to somebody else who already has complementary patents. So now, I did say that we would try to go through a case study at the end, and I think I still have time. This is the case study covers closed-loop artificial pancreas for type 1 diabetes. I've used this because medical devices often cover multiple different types of IP because they have hardware and software. So firstly, as I said, we're going to look at what is the background for this. Well, we've created a beta version or a proof of concept version of an insulin microdrive of this technology. And this technology, part of the software you've downloaded from the MIT website. The insulin microdriver was taken out of an old Medtronic pump. And you've also identified key clinical trial that was funded by the MRC with a commercial collaborator that you're going to need to use in your future research. So looking at this, you may need to get a software license. You need to look at this MIT website to work out what the commercialization terms or what the research terms are for that piece of software, and work out if you're able to get a license if you need to commercialize. For the insulin microdriver, you need to work out whether patents exist on this. And if there is patents, are they still active? And if they're active, will you be able to get rights to use this microdriver? If you can't get rights to it, do you have a backup plan? And finally, with the key clinical trial, well, are the right consents in place for this key clinical trial? Who actually owns the trial data, or who's the custodian of the trial data? Because data is not owned. And how will you be able to get access to it, and through what agreements? For this research, you plan to work with J&J to improve the user interface. Hopefully, you will collaborate with Harvard to improve the algorithm. You have identified a patient-reported outcome measure that was developed at Cambridge that you would like to use in your research. And you've also decided that you would like to brand this the Oxford Artificial Pancreas. So if you want to, obviously collaborations are often required, and that's not an issue. But if you're about to collaborate, especially with an industrial partner, you need to understand who is going to own the arising IP and how that's going to affect commercialization down the line. You need to put agreements in place that cover this before you start the collaboration. And you need to work out whether, if you work with we have J&J here, but if you work at one particular industrial partner, does that link you to that industrial partner for your commercialization, or are you able to work with other industrial partners? If you would potentially need to put a collaboration agreement in with Harvard to improve the algorithm. And because the patient-reported outcome measure is developed at Cambridge, you would probably need to work with your TTO in order to put agreements in between the two TTOs. And finally, you would need to think about putting a trademark in place for the Oxford Artificial Pancreas. You need to work out whether that trademark already exists, or whether you're allowed to use the word Oxford in the name of any of your products. You can do this in a quick and dirty way by doing an intensive internet search. But if you were to start thinking about trademarking and creating branding strategy down the road, you can hire experts in this area to do an in-depth worldwide search to work out whether you will be able to trademark that. Often I've liked to work out whether I'm able to buy the domain name around that, because it often tells you whether somebody else is using something very similar already. And finally, looking into the future, you know that Biobeatronics filed a patent covering this type of system in 2000, and an insulin pump can only work with the Abbott Freestyle BG monitor. So you need to work out whether your potential there is a potential that your new research is going to infringe on any of the patent claims in this patent, and if it does, can you license this patent from Biobeatronics? Or if for the insulin pump, you might want to work out whether there's an alternative pump, because it creates a commercialization risk if you're stuck to one piece of IP. So finally, I just to put that all, just try to summarize all of that. When you're creating your IP strategy, ensure that you protect before you disclose. Do not let IP management and the IP section be an afterthought. As you can see, it very intrinsically links to the research plan itself. Identify the IP that you are going to need to use or you're going to generate early. Define who owns that IP, and create a strategy for IP owned by others that you need to use. If you're not able to get it, you need to create a strategy for alternatives. For IP owned by you, ensure you protect that before you disclose. Your commercialization, exploitation, and IP strategy should align all the way to getting your technology into the hands of the clinicians and the patients. And seek advice early. Ask for the support from your tech transfer office or a similar entity, experts as early as you can, in order to ensure that your IP strategy has the best chance of getting funded.